All right. So, good afternoon, everyone. Welcome to a very special webinar from our Center for Environmental Law, Macquarie University's event on Ukraine crisis. So, my name is Nengye Liu. For those who don't know me, I'm the director of the Center for Environmental Law here at Macquarie. Before I get started, I would like to acknowledge the traditional owners of the land, the Watamanaga clan of the Daro Nation, whose culture and customs have nurtured this land where I'm in, and also they will continue to nurture in the future. And I pay my sincere respect to elders past, present, and future. Today we have this very special event, which was initiated by myself over the last weekend. We are all shocked by the war in Ukraine. And also, I guess for those who are in Sydney and Brisbane, we are also experiencing this extreme weather, the flooding at the moment, which is horrifying as well. I must say, starting from 2019, personally, really just personally, I feel like we are really living now in a more and more kind of dangerous world. There are probably two major existential threats to our species these days, being the geopolitical tension and climate change. And we are now witnessing the extreme symptom of both of these two existential threats to our human beings. In this time of history, and while a war is going on, people may well ask, does international law matter? And also, I have seen people asking on my Twitter, like, does the environment matter? I think my short kind of answer is, I think they are both actually interconnected. So peace and environment are interconnected. And what we choose to do now will rightly shape our future. That is probably why the UN was established after the Second World War, after the two brutal world war in the first half of the 20th century. And also, you know, when we are talking about this, I think now there is news all over the place that Europe's largest nuclear power plant is now on fire. I mean, this morning's news under Russian attack. So, I mean, the thing is, I think when we are thinking of the environmental crisis in Ukraine, Chernobyl is not far away. And now, after 30 years of the collapse of the Soviet Union, Ukraine has inherited a number of nuclear facilities from the Soviet time. So, I mean, what we are talking about today is a very important, and we certainly think shouldn't be a forgotten issue. That is the state's obligations for the environment during the armed conflict. And we are very lucky to have Dr. Eve Massingham with us today to give this talk. So let me just give a very short introduction about Eve. So Eve is currently a senior research fellow with the School of Law at the University of Queensland. I think her expertise is pretty much in the law of the armed conflicts, the international humanitarian law. So she has done a PhD on weapons law. She used to work for a decade at the for the International Red Cross and the International Committee of the Red Cross Regional Legal Advisor for East Asia. And in recent years, I have noticed, that's why I invited Eve, is Eve's expertise now falls into this very special area of the international humanitarian law, that is to ensure respect for environment during conflict. So this is very much the right topic with the right person to discuss this very imminent issue today, and we are very lucky to have Eve with us. So with all this introduction, now I will just hand over to Eve for the presentation. We are in a Zoom meeting, so for participants, you are welcome to either put your question on chat, or at the end of the following each presentation, we will probably have, let's say, 20 minutes for Q&A, and you can turn on your video and ask questions by yourself. All right, With no more, Eve, the floor is yours.
Lovely. Thank you very much for the kind introduction. Hopefully my screen is sharing nice and clearly there. So yeah, thank you very much for the to the Centre for Environmental Law for the introduction and the opportunity to talk to you today. I'm joining this webinar from Meanjin, the lands of the Turrbal and the Yagara people. This has been a place of teaching and learning for many thousands of years, and I'm very privileged to live and to work on these beautiful, if somewhat waterlogged at the moment, lands. I pay my respects to elders past and present. As was just mentioned, and some of you will be aware from news reports in the last hour, you know, this breaking news is coming in that Europe's largest nuclear power plant is on fire after Russian attack. Now, I certainly can't pronounce, and I'm not going to attempt to pronounce the name of the power plant, but just to sort of alert you, I've thrown this in just now, but I am going to talk about the nuclear facilities, of which there are a large number in Ukraine, and of course Chernobyl, that people will be aware from a few days ago has already been captured by Russian forces. So I will come back to the nuclear issue. Just to give you a bit of an idea of my outline for today, I'm going to make a few introductory remarks about the laws of war and international humanitarian law in the broader context of both international law and environmental law. As has been pointed out, I'm an international humanitarian lawyer. I've spent my career mainly working with different components of the Red Cross movement on education and understanding around international humanitarian law. So I'm not an environmental law expert. I'm also going to make some observations about enforcement. This tends to be something that we talk about at the end of international humanitarian law presentations, but I think it's something that always gets questions, and so I wanted to put this up front. Talk a little bit about the environment in Ukraine, and specifically just really from news reports over the last 10 days, some of the issues that have been raised. And then I want to take you through the general rules of international humanitarian law and the specific protections that apply to protect the environment in times of armed conflict, and talk a little bit about weapons law as well. And if we do have time, I'll also talk a bit about ensuring respect for international humanitarian law, which, as was pointed out, is part of one of my sort of research projects at the moment. So in terms of international humanitarian law as part of international law, in talking about this topic, I think it is particularly important and relevant in light of the tragic events unfolding in Ukraine this week to note that this is a Russian invasion of Ukraine in clear violation of the legal prohibition on the use of force in international law. Now, this is a separate area of international law on use of force, and many of you will be very familiar with this. This is a violation of Article 2.4 of the UN Charter. If anyone is interested and hasn't already seen it, the Blavatnik School of Government at Oxford University held a webinar on this a couple of days ago. You can easily get it on YouTube. And Professor Dapo Akande speaks specifically to the Article 2.4 violation issue. What is significant, of course, about this from an international humanitarian law perspective is that because we have an armed conflict which very clearly involves two states, we are talking about the rules that apply in times of international armed conflict, which is a much broader category of legal laws that are a part of international treaties. And some of the challenges that we have around questions of customary international law and questions of applicability in non-international armed conflicts, which many of today's armed conflicts are, just don't apply. So I think that's an important first point. In terms of these very specific rules that apply during conflict, it's also important to acknowledge there are a range of other international laws, and there's some incredibly interesting discussions which many of you as environmental law experts will be much more familiar with than me, of course, in terms of obligations to prevent transboundary harm, human rights to a clean environment, just to name a few. So international humanitarian law that I'm going to be talking about is just one part of the legal framework. And there are a whole range of laws protecting the natural environment, including environmental law, law of the sea, for example, some aspects of international criminal law. And of course, the law on state responsibility also has relevance here. So I'm certainly not purporting in any way to cover the full gambit of different legal frameworks that might be relevant. But when you do have an armed conflict, there is this specific legal framework, international humanitarian law, to discuss. And a point that comes up in a number of the discussions and has done since the 70s, when sort of a lot of this environmental legal framework really took off in global discussions, is this question about whether international humanitarian law is protecting the environment for its intrinsic value, and not just for the survival of the civilian population. So you may be aware that a lot of the provisions of the Geneva Conventions are about protecting civilians and protecting them and their ability to provide for themselves. Now, this debate was an ongoing debate, even back in the 1970s, leading to Additional Protocol 1 to the Geneva Conventions, which I'm going to refer to in some detail in the presentation. Some delegates in attendance were of the view that the environment in times of war itself should be protected for its intrinsic value, and others considered that the purpose of the environment from an international humanitarian law perspective is the continued survival and health of the civilian population. And so you can see those different perspectives in the official records of the Diplomatic Conference of Geneva in the 1970s. Although IHL perhaps does not traditionally protect the environment in the sense that we sort of today understand the green movement, and the focus is primarily on civilian survival, concern for the environment has definitely been reflected in international laws since the 70s. And I think it's fair to say that there is more to come in this space. The International Committee of the Red Cross rightly pointed out in their very recently published guidelines on the protection of the natural environment in armed conflict, a 2020 publication, and a work that if you're not familiar with, I commend to you as the excellent efforts of former colleagues of mine, including Vanessa Murphy, who's one of the key drafters. They point out that efforts are underway to clarify and strengthen the international legal frameworks in armed conflict. And definitely state interest in this topic has gained momentum. You might be aware that the International Law Commission has appointed a couple of rapporteurs on this and produced draft principles on the protection of the environment in relation to armed conflict. States responded to that document in 2021. And further discussions are due to start in April 2022 on this document. So a little bit, and I'll probably say this a couple of times, but there's a little bit of wait and see in the space of sort of protecting the environment in times of armed conflict, but it's definitely a topic of hot conversation, even prior to the events of the last 10 days. So that's what I wanted to just sort of place this conversation in the context of broader international humanitarian law, broader international law, but also broader developments in international humanitarian law. Now, on the question of enforcement, and of course, it's very hard to have any IHL conversation without thinking about enforcement. I wanted to make a couple of points. Firstly, a very clear acknowledgement from me, even as an international humanitarian lawyer, who this is what I do and am absolutely fascinated by, but very happy to admit that the legal framework is not a perfect solution. Indeed, if you think about the context of international humanitarian law, it is only ever going to be a plan B. The first point, the use of force violation that I referred to just before, is where we really we really start the conversation. And it is only when mankind has failed in its ability to prevent the use of force that international humanitarian law even applies. It applies in times of armed conflict. And it acknowledges that it's a plan B. It doesn't purport to have all of the answers. That said, there are very significant developments this week from an enforcement perspective. You can see a couple of screenshots that I've just taken there from the homepage of the International Criminal Court with a very quick development to an opening of an investigation for the situation in Ukraine. So the prosecutor, Karim Khan QC's decision to open an investigation and supported by a number of states, not because either Ukraine or Russia are state parties, but rather because Ukraine has basically allowed the International Criminal Court to take on this investigation. So that is happening, and damage to the natural environment constitutes a war crime under various different provisions of the Rome Statute of the International Criminal Court. And so there is absolutely the possibility of some criminal sanctions arising from this conflict, and we can certainly talk more about that in questions. The second aspect of enforcement that I just wanted to mention is the sort of the compensation or even going forward, I think more restoration aspect of it. And so you might be aware that the UN Compensation Commission following the first Gulf War paid required the payment of reparations for Iraq's invasion of Kuwait. Now, Payne and Sand have done some work that has noted that over about $5 billion of the $52 billion in total was paid for claims relating to environmental damage, including damage from military fortifications, water pollution, hazardous waste. Now, of course, we're talking about quite a different situation in this context, with Russia being a permanent 5 member of the UN Security Council. And so something like that may, of course, not come out of it in this context. But I just wanted to note the inclusion of environmental concerns in a UN compensation system. And also note that going forward, there is a greater focus on restoration of the environment. The African Convention on the Conservation of Nature and Natural Resources, which was updated in 2017, included in those updates some requirements for parties to actually restore and rehabilitate damage resulting from military and hostile actions. And this is definitely something of interest to the UN. So again, a little bit of a wait and see space, but I wanted to mention that. Now, this is sadly a very small snapshot of the ever-growing list of some of the concerns over the last 10 days that have been environmental impacts from the conflict in Ukraine. So the use of explosive weapons in populated areas, radiation from explosive weapons and fighting around nuclear facilities, the groundwater contamination. You know, there is a lot to discuss here. I'm certainly not an expert on the environment of Ukraine, so I did a few Google searches this week. I found that Ukraine has 33 internationally significant wetlands, and although it occupies only 6% of Europe's territory, it has 33% of its biodiversity. As I said, these are quick Google searches, so don't quote me on it, but clearly the impact on the environment will only be exacerbated by already fragile ecosystems. And this is, of course, against the backdrop of serious ecological destruction from earlier fighting. So a 2018 UN Environment Programme report noted Donbass being on the precipice of an ecological catastrophe fueled by air, soil and water pollution from the combustion of large amounts of ammunition and fighting and flooding at industrial plants. You know, this is clearly an ecological catastrophe on both the biodiversity, fragile ecosystems perspective and the already contaminated ecosystems aspect. And then There's the question of carbon emissions from military activity as well. This has been a big topic of conversation in recent times, or especially around COP26 and the discussion of sort of monitoring carbon emissions. So it's all, it's all not looking good for the environment and obviously for the civilians who rely on that environment. So to turn now then to give you a bit of an idea about some of the provisions of the Geneva Conventions and particularly Additional Protocol 1 that I wanted to share with you as part of the conversation. I think firstly, I just want to note that Ukraine and Russia are both state parties to not only the Geneva Conventions, which all states are party to, but also to Additional Protocol 1 to the Geneva Conventions. And so sometimes when we have these conversations, we have to have discussions about, is this customary international law? But these are binding as treaty provisions on the parties to this conflict. Now, IHL seeks to reduce the suffering during times of armed conflict, and it, as I said before, primarily protects the environment insofar as it provides for the civilian population. And what is clear is that in the history of international humanitarian law and the development of the regulations in this area, protecting the food sources and clean water and the needs of the civilian population has been central. And there really are two prongs to this here. I think first, protecting the environment against the damage itself, and irrespective of whether we're talking about it from an intrinsic value point of view or from a human protection point of view, or actually both because they're so intertwined. Or we're talking about protecting the surrounding environment from damage when attacking objects. But the provisions that you can see on your screen are relevant to all of these. So the protections are for civilian objects. The environment is at first instance a civilian object and therefore protected from attack. And under the core principle of distinction in international humanitarian law, the environment can't be the subject of attack. However, the framework of international humanitarian law is such that civilian objects are effectively defined as being not military objectives. And so to define a civilian object, you need to look at the definition of military objectives. And military objectives are those, not just the obvious ones, the tanks and the military bases, military by nature, but military objects are also those that are used or have a purpose or location that makes an effective contribution to the military effort. And so at first instance, if you think about where the natural environment is being used as a military objective, then if an attack on that doesn't cause disproportionate effects to the civilian population, it could be lawful if the appropriate precautions are taken because it's a military objective. It's become a military objective. However, because of these special provisions in Additional Protocol 1, and this is very much, if you think about the context of this, negotiated in a post-Vietnam War era, and in particular, the tactic of spraying Agent Orange on vast areas of land, led to the prohibition of particular tactics that may cause widespread, long-term and severe damage to the natural environment. And you can see that in Article 35(3) of Additional Protocol 1. And in particular, you can see in Article 55(1) that care must be taken in warfare to protect the natural environment against this widespread, long-term and severe damage. Now, there is a reference in the second part of this provision to the prejudicing the health and the survival of the civilian population as well. And there is, as you can see on the screen, also Article 54(2) of Additional Protocol 1, which is prohibiting the attack on objects indispensable to the survival of the civilian population, foodstuffs, agricultural areas, etc. So both attacks on the environment itself, even when being used for a military purpose, and attacks on objectives that would cause a heightened environmental destruction to the surrounding areas are therefore prohibited by these particular provisions. If the civilian natural environment is commandeered by the military, if their appropriate precautions aren't taken, then attacks on those, albeit military objectives, are not allowed. Now, we've seen, in addition, obviously, to the nuclear issue, which I'll turn to in a moment, we have seen reports of Ukrainian oil and gas facilities being hit in the past week, for example. There's obviously the legal and the factual questions about whether they're being used for military purposes or not. But if they are being used for military purposes, if care is not taken to protect the natural environment against the widespread and long-term severe environmental damage in those objectives being attacked, pursuant to Article 55, then you potentially have a violation of international humanitarian law. Here I have mainly talked about the additional protocol to the Geneva Conventions, but just to also mention that there are some other instruments, some soft law and hard law. So, for example, the San Reno Manual on International Law Applicable to Armed Conflict at Sea talks about identified marine areas containing fragile ecosystems or habitats to be given special protection. And this is potentially a forthcoming issue for further discussion based on the reports that I've just been reading this morning about a potential naval attack on Odessa. There's also, for example, protections under the World Heritage Convention for places and property of particular significance under that convention. So if we turn then to look at the nuclear issue, there's some 15 nuclear reactors on Ukrainian territory. And in addition to these major news reports that we've seen in the last hour or so about the nuclear power plant being Europe's largest nuclear power plant being on fire, we've already seen the reports of a roughly 20-fold radiation spike recorded around Chernobyl. And BBC News reported that this was caused by heavy military vehicles stirring contaminated land around the exclusion zone. So there is, a very significant risk for the environment and for populations and for the global community around these attacks. One of the things that I just saw in the news reports was that Ukrainian authorities were saying, can we please have, a ceasefire? I'm not sure if they were using it, the pleas in quite the way that I just did, but can we have a ceasefire around this facility so that we can put this fire out that's taking place at this nuclear plant? And so I'm not suggesting that there was any military use of this facility. I don't have information about that, but even if there was some kind of idea that this was a legitimate military objective, it's clear that the appropriate precautions which are required by the provisions of international law, like allowing the fire to be put out, are being challenged at this very point in time as we speak. And there is obviously a hugely grave concern around this. Now, the fact that this sort of thing could happen was, of course, something that was conceived by the Geneva Conventions and the drafters. And so we see in Article 56 of Additional Protocol 1, this particular provision for dangerous forces. And so nuclear facilities, as part of that, have special protection against attack. And this because the release of dangerous forces from these facilities is of grave concern. And so this is something else to be aware of in this particular context. And then, of course, there's the issue of weapons and the various weapons that are being used and the significant environmental consequences for this. And I'll talk a little bit generally about weapons, but I'll also make some observations about nuclear weapons. So the rules of international humanitarian law prohibit the use of weapons that have the following characteristics. So firstly, those with indiscriminate effects. Secondly, those that cause unnecessary suffering or superfluous injury. And thirdly, those that are intended to or may be expected to cause widespread, long-term and severe damage to the natural environment. In addition to these three core rules, there are specific weapons law treaties that have a range of provisions, particularly prohibiting certain weapons. And so poison, biological weapons, chemical weapons, herbicides such as Agent Orange are prohibited by particular treaties of international humanitarian law. I thought I'd mention a couple of types of weapons that have come up on the news this week. So one of them, you will have seen reports about white phosphorus. This often comes up in these type of conversations. This is an incendiary weapon, so it's intended to set fire and burn, and obviously that's very concerning for civilians and also the environment. Now, its use as a chemical for attacking targets is prohibited by the convention on certain conventional weapons, but its use as a sort of signalling or illumination as a military tactic is not prohibited. And so there obviously are therefore, two ways of using it. One is okay and one is not, but this is something to bear in mind when you're seeing the news reports. And of course, even in the illumination or signalling aspect to it, there are precautions that need to be taken to protect the civilian population and the civilian environment. The other type of weapon that I've seen quite a few news reports this week about is these thermobaric or vacuum bombs. They seem to be being called by the media, which causes a shockwave, which basically sucks the air from the lungs. Now, this is not a new type of weapon. They've been used since the 1960s, and they come in various different sizes and methods of deployment. When used against military targets, they're not specifically illegal, but there's clearly circumstances where their use would be problematic. However, I haven't really been able to find any kind of environmental discussion about their use, but there could be some serious environmental consequences from their use. Although, of course, there are serious environmental consequences from many weapons that are lawful, and the explosive remnants of war aspect and the radiation aspects of different weapons are very concerning to the environment as well. Finally, then, sorry, just to go back, just to say a few words about nuclear weapons, which is something that I've done a bit of work on and looked at specifically in my PhD. You may be aware that as of about just over 12 months ago, there is a treaty prohibiting the use of nuclear weapons. This is a long discussed idea that has finally come to fruition. But of course, neither states are party to that treaty, and it is a very new treaty. So to consider nuclear weapons, I think a lot of us still go back to this advisory opinion by the International Court of Justice in 1996 that gave us this very unhelpful, if I believe, conclusion of sort of not really answering the question. In that case, it was held, and this was a 7-7 decision by a president's casting vote, that you couldn't conclusively conclude that nuclear weapons would be illegal in an extreme circumstance of self-defense. Now, I believe that the court, insofar as they did conflate the two, erred in conflating international humanitarian law and the use of force in that judgment. And I believe and agree with those judges, and including in this the president, who observed that this decision wasn't made because nuclear weapons as they stood at that time could ever be used in compliance with IHL. It was made on the basis that there could be new technological developments in the future that included a nuclear weapon that could be used in compliance with IHL. I think that since 1996, we've come some way in those understanding of the technology. The US Department of Defense and Energy, about a decade later, said that, look, it's just really not possible to have a lower nuclear weapon capable of not causing this collateral damage. Indeed, the Hiroshima and Nagasaki nuclear bombs are considered small, low-yield nuclear weapons. And discussions through the 2010s leading to the creation of the Treaty on the Prohibitions of Nuclear Weapons made it really clear that this is just not an option. So I would hope that the decision would be made differently these days in light of all of the information we have about the inherently indiscriminate nature of the weapons, the unnecessary suffering and horrendous intergenerational impacts of these weapons, and also the alarming consequences for the environment, for climate change, for rainfall, temperature, food production, for everything environmentally related. So the fact that reports are that Russian nuclear weapons are on high alert is incredibly concerning for a whole range of reasons, primarily humanitarian, but is also very legally problematic. I think we're pretty much out of time to allow some time for questions. Where does this leave us? Well, clearly there's going to be some horrendous environmental destruction in Ukraine as a result of the conflict. Crimes have already been committed in violation of IHL, including those on the rules protecting the environment. And there may be some charges in due course and some compensation payable. To say a few words about efforts to stop this happening, I guess, in the future, just to mention again the ICRC guidelines and the practical steps that they suggest to take. And this is definitely not in relation to the current context. It's all too late now, of course, but in terms of education and training, designating areas of particularly fragile ecosystems and environments, setting up particular zones, demilitarized zones to try and protect the environment are things to consider going forward. And I think there are, a range of things to discuss in the area of international humanitarian law and the environment, the protection of the environment itself, its intrinsic value, the types of compensation and rehabilitation that might take place. So I'll leave it there to allow some time for questions. But just to say, I think there's clearly some horrendous consequences that are taking place. International humanitarian law absolutely does not have all of the answers. It's not going to suddenly make everything better, but there are some very clear legal provisions that are being violated, and there may be some consequences down the track for that.
Thank you very much, Eve. I think this is very comprehensive, and I mean, at least we need to talk about it. We definitely need to talk about it in this time of crisis and war and everything. And there are existing legal obligations in this imperfect international legal framework. I mean, it's not just about international humanitarian law. International law in general is imperfect, but it doesn't mean that we don't aspire to improve and also make sure it's compliance. So now we have, I think your timing is perfect. So now we have 20 minutes for questions. So the floor is open to the audience. Anyone, if you have a question, please just turn on your video and introduce yourself and ask your questions. I guess people need to warm up a bit. After a very gloomy. Well, it's not a gloomy talk, but it's a gloomy talk after listening to a gloomy topic.
Gloomy subject. I think I can see a couple of hands up.
Oh yeah.
I don't know if they're waiting on you to call.
Yes, sure. So I think the first one is Dr. Srivatini from University of Indonesia, I believe. City. I saw you in our Frontiers conference. Yeah, please go ahead.
Thank you very much. But I'm so sorry I cannot on cam because the internet maybe will be disturbed. Okay. Thank you very much for the opportunity. This was very good presentation related to the conflict of Russia and also Ukraine. So that's the humanitarian law will be applicable. But however, that the attack of Russia also has some kind of violation of humanitarian law, because based on the news, I hope that the news is correct, that's the attack also addressed to the civilian object. so that the civilian is become the victim, and also the impact of the attack also will come to the environment itself. So in the international law that we know, we have such kind of state responsibility, and when the state doing such kind of damage to other state. But in this case, that if this kind of matter happens, so if we referring to the humanitarian international law, it will such kind of we can say that Russia can be said as already conducted war crime. So based on your opinion, so it will become the state responsibility, or it will become the individual responsibility, will be that the president of Russia will be responsible for this attack, because that is a different speed of this kind of principle with this individual responsibility or state responsibility. Thank you very much. Okay, thank you.
Thank you. Is that a comment, more or less? Eve, do you want to respond?
Yeah, so as I understood the question, and thank you for your question and joining us from Indonesia, the question is essentially, is this a state responsibility issue or an international criminal law issue? Is that correct?
Is a state responsibility issue, or is it based on the humanitarian law? Is about international criminal responsibility? Yeah.
Yeah, so my response to that would be, the answer is both. So there will be aspects of the conduct coming out of any conflict where there are individual criminal responsibility aspects and for violations of international humanitarian law, where individuals will be held responsible. And international humanitarian law is this sort of quite particular part of international law where you are actually, for many of the provisions, talking about the actions of individuals, and individuals having a liability either as a commander or as a perpetrator. And so individuals going to the International Criminal Court on war crime charges is absolutely how international humanitarian law prosecution ordinarily plays out. But there is, of course, also the additional element of state responsibility. And so for where an internationally wrongful act has occurred, and as I said, I'm not an expert on environmental law, for example, but I would imagine there are some internationally wrongful acts that have occurred and will occur in this context that are violations of parts of international environmental law, for example, then state responsibility, where that's attributable to the state, either through a state actor or the rules of attribution, could be state responsibility, and compensation could be payable for those internationally wrongful acts. So my answer would be, absolutely both areas of international law would apply. And also, my thing, as I mentioned, is ensuring respect for international humanitarian law. So whilst most of international humanitarian law is directed at individuals and their individual criminal responsibility, there are a large number of provisions of international humanitarian law that are directed at the state. The state has a large number of obligations, and in particular, Common Article 1 of the Geneva Conventions requires the state to respect and ensure respect for international humanitarian law. So I think there are a number of avenues whereby there could be international criminal or international legal repercussions, in addition to all of the sort of policy and political and diplomatic repercussions and sanctions and the like that we're seeing now.
Good, thank you very much for your explanation.
Yeah, Jennifer? I think, Jennifer, you have a question?
Yes. Hello, Eve. Yes,
hi, Jennifer.
The International Criminal Court. Hi, good to see you. So I like this area very much, and I teach it in a course when I get to run the course. I went to the ICC when it was in its old building, so about 3 years ago, and met with the prosecutor, who had showed me very proudly a document they had drafted that would give the prosecutor under the ICC statute, more scope to launch actions on the basis of environmental damage, or either actual or the behaving in a way that uses the same words, widespread, so on, damage. I wondered if you had any comments on that, or and if it's likely to be applied.
Thanks, Jennifer. Yeah, so look, I don't have any comments on that specifically. I mean, I think my initial response is that obviously the ICC is, there are so many different aspects and so many different horrendous things that happen in conflict that, the ICC has to prosecute under its statute. It has to prosecute, those most responsible for the most serious violations. So it's I think pulled in so many different directions. I mean, we've seen it sort of focus on child soldiers. We've seen it focus on gender violence and rape and other offences of a sexual nature in armed conflict. We've seen other courts and tribunals, for example, focus on destruction of cultural property. There are so many difficult directions in which the court can be pulled. But I certainly think that because in particular in a context like this, where we are talking about sort of, anything with the nuclear reactors, we're talking about environmental destruction on just, a scale, of course, that we haven't seen since nuclear tests in the Pacific or, even the Second World War. So if there is something nuclear, then I don't see how it wouldn't be in the most serious of crimes. Obviously, the International Criminal Court is not able to prosecute every violation of IHL that takes place in Ukraine during this conflict. That won't happen. But where there is an environmental crime within the context of the court statute that does fit that serious category, then I absolutely can see that being a focus. And I think that the document that you're talking about that sort of strengthens the court's interest in that shows the acknowledgement that, that could fit into that category of those most responsible for the most serious of crimes. So that would be my initial response to it, but I'm sure there's also some other thoughts on that in the group assembled, just looking at the names that I've got. So feel free to put anything in the chat if anyone wants to add to that.
Thanks. So Kirsty, you got a question?
Hi, Eve. Thank you so much for today. It's obviously a super confusing time. So the way that you've presented it has been brilliant in terms of explaining everything in so much detail. And I feel like you might have covered one of the questions, which was just around the fact that Russia isn't party to the treaty on the prohibition of nuclear weapons. So does IHL sort of step in? And you might have sort of talked about that in the last question. And then the other question related to your point about Chernobyl and the increase of radiation around there because of military vehicles. And I just wondered, like, this is, I guess, slightly separate from the environment, but whether there are any rules in terms of how that's affecting the soldiers, the military, like the army and soldiers that are going through there and are affected by that, particularly in terms of their long-term effect from radiation, potentially.
Thanks so much, Kirsty. And I'm going to have to disclose that I know Kirsty as a fabulous researcher for us at UQ. So thanks for your questions. The first one in relation to the Russia not being a party to the Treaty on the Prohibition of Nuclear Weapons. It's certainly my view that IHL absolutely does step in, and it's my view that IHL prohibits the use of nuclear weapons. There obviously are states that disagree with that position, and there are states that have made that disagreement with that position very clear in terms of reservations to though the relevant provisions not applying to nuclear weapons. But based on my reading of the ICJ judgment, my reading of international humanitarian law, and all of the evidence that was presented during the 2010s, there were 3 conferences on the humanitarian consequences of nuclear weapons in Oslo, Nayarit, and Vienna. And during those conferences, you know, all of the evidence made it really, really clear that there just isn't a way to limit the effects of these weapons, and those effects are more than widespread, you know, more than long-term, you know, intergenerational and the like. So, yep, it is my view that absolutely IHL very clearly prohibits the use of nuclear weapons in times of armed conflict, and I don't quite see how you could use a nuclear weapon without an armed conflict. So I think that not being a party to the treaty doesn't change anything. On the second question, I think it's a bit of a tricky question. It's an important question about what are states' obligations to their soldiers in terms of putting them in harm's way. And I think a lot of this comes down to sort of domestic law, and there certainly are claims by military personnel in various different jurisdictions around the world, not even just in conflict, even just sort of in workshop kind of settings, for having been exposed to toxins and chemicals and radiation and the like. So international humanitarian law doesn't really talk about it from the perspective of your own soldiers and looking after their health and safety, but certainly other aspects of international and particularly domestic law do.
Yeah, so there is one question from my Macquarie colleague Konstantinos on the chat. So he asks, are nuclear plumes into neighboring states a trigger for those states to react militarily?
Haven't thought about this before. My answer is no, because you can only respond. And no, actually, I'm sure about this. The answer is no. You can only respond if you're responding in self-defense, or if there is collective intervention, UN Security Council agreement to do so. So there is absolutely a range of legal obligations in relation to transboundary harm. There'll be many more expert environmental lawyers on here who can tell you more about that. There are many possible responses, but an armed attack, which is what I assume you are meaning by reacting militarily, would not, in my view, be lawful.
Great. Anna?
Yeah, hello. So sorry, these questions are a bit silly. I'm a political philosopher, so excuse myself. But, you know, the first question regards the International Criminal Court, and I wanted to know if it can actually prosecute someone in absence or not. You know, I thought that it cannot, which if it cannot, it means, you know, the effects are actually quite limited. And the second question regards the Geneva Convention. And I'm mostly interested not in the written words, but mainly in the mechanism of actually holding the state, you know, accountable for violations of the Geneva Convention, because it seems to me that, well, there aren't any mechanism or any practical ways. So in terms of the practical effects of the Geneva Convention, you have a government that doesn't even recognize the situation on the war front, and, you know, obviously doesn't recognize any losses, any the facts of the war. Then it's very hard to actually, yeah, it's very hard for these sanctions to bite, right? I mean, it seems to be dependent on, entirely dependent on whether the regime, the Russian regime, is going to change or not, right? Thank you.
Thanks, Anna. So just on the prosecutions in absentia, so the ICC, you're correct, it has never done that. My understanding, and I would definitely have to go back and recheck the statute, but my understanding there is that possibility. Somewhere in the rules of evidence and procedure, there is something around the possibility of doing that, but it is not something that they have done. That said, there are you know, a significant number of states and a very significant number of you know, key states that other states need to interact with who are state parties to the International Criminal Court. So if, you know, down the track, if an indictment is issued for the arrest of, you know, for example, it's senior people within the Russian administration, there is a legal obligation on state parties to the ICC to arrest that person if they come within their jurisdiction, and transfer them to the International Criminal Court for that prosecution. So whilst, you know, there may not be an immediate ability to do something, an indictment by the International Criminal Court, if you're trying to lead a country or be a senior leader in a country and you are not allowed to travel, or you are not able to travel to 2/3 of the world, you know, there are some very serious problems that arises from that. So I'm not saying that that's a perfect solution, but the restrictions and sanctions and inability to interact in the global community that would come from an ICC arrest warrant are incredibly significant. And, you know, we are talking about, you know, if we are talking about Putin, for example, we're talking about someone who, you know, does attend and travel and go to global conferences and all the like. So there is something there. In terms of, you know, sort of general, I think the second part of your question is sort of like a general concern about, you know, the bite and the ability of the Geneva Conventions and to do anything. I mean, you know, I think the point that was made about the sort of international law is absolutely not perfect. You know, actually every single country in the world is a party to the Geneva Conventions, which is a pretty incredible feat in and of itself. There, you know, yeah, absolutely not perfect, but there is things that can be done to make life difficult for people who are violating the conventions. And yeah, I mean, perhaps again, just to refer you to the Blavatnik School of Government's talk, there were observations by Harold Coe as well about, you know, what this would mean for Russia and what sanctions are. And there was some really interesting, there was 5 experts on that panel and some really interesting observations. So I'd refer you in that direction.
Right. The last question from Catherine, and 1 minute to 2. Catherine.
Hi, I just have a question for you regarding humanitarian organizations when it comes to like nuclear contaminated areas. So before, when you were giving the example of the ground that had been churned up by military vehicles and how that is now, I guess, a dangerous area, how does that influence organizations such as, you know, the ICRC or other humanitarian organizations in their efforts to help civilians?
Look, it's a really good question, Catherine, and it's absolutely something that was very much a topic of conversation during those 3 conferences leading to the Treaty on the Prohibition of Nuclear Weapons that I mentioned. That was one of the conferences. So the final of those conferences was held in Vienna. And when we turned up to that conference, we were greeted at the front of the conference venue as we went through this amazing, sorry, I can't remember the name of the building, but this amazing, lovely, old, very old building in Vienna by volunteers from the Austrian Red Cross in full hazmat suits. And I mean, I don't think it was doing anything, but basically they had the little swipey things that, you know, went to check the contamination on your body, and you had to put your bag through this. It was, you know, just a process of sort of making it clear that we were coming into this uncontaminated zone for these days of discussions. But, you know, this idea has been really clearly come from the World Health Organization and from the humanitarian community. We do not have the ability as a global community to respond to the fallout from a nuclear weapon because of the health impacts, and that these will also, obviously, they don't just impact on the people who are there when the bomb is dropped, they impact on the people who go into that area. The US strategic bombing survey from Hiroshima and Nagasaki sort of outlines a whole, range of consequences and things that have happened to people, and intergenerational effects for people who weren't even there when it happened, but who went into the area. So I think the answer to your question is no, we don't have the capacity to provide a humanitarian response.
Yeah, thank you very much, Eve, and all the wonderful participants. And I think we had a very fruitful discussions on this very gloomy subject. But I hope everyone enjoyed all these kind of different perspectives and obligations and under the international humanitarian law framework with respect to the environment. And our webinar will end here, but our dialogue will continue. And thank you once again, Eve. And thank you, everyone.
Thanks for having me. Thanks for the interesting discussions.